Did the Constitution create a union of states or a central government with 50 administrative subdivisions? I suggest it's by far the former, that there are rights, there are powers that are reserved to the states by our Constitution. We are hearing it said today that the Constitution is the supreme law of the land, and Article 6, Section 2 says that. It says the Constitution, laws made under the authority thereof, and treaties made or shall be made under the authority of the United States shall be the supreme law of the land. There's something missing there. I don't hear anything about decisions of federal judges. But when the Constitution is the supreme law of the land, it created a union with most powers reserved to the states. And the Constitution itself is based upon an even more fundamental document, the Declaration of Independence. You might say the Declaration created the nation. The Constitution created the government. And the Declaration rests upon something higher still. As that introductory sentence of the Declaration says, the laws of nature and of nature's God. Now, when we say the Constitution is the supreme law of the land, what part of the Constitution is the supreme law? All of it. And that includes the 10th Amendment, because Article 5 says that amendments, when ratified, are for all intents and purposes part of the Constitution. And the 10th Amendment simply says that the powers not delegated by this Constitution to the federal government or prohibited by it to the states are reserved to the states respectively or to the people. Now, is there anything in the Constitution that delegates power over marriage to the federal government? If I were grading a class, I'd give you an A. You got that right. No. Is there anything in the Constitution that prohibits that power to the states? The answer again is no. Therefore, the power over marriage is reserved to the states, and that is the 10th Amendment. That is part of the Constitution, and that is the supreme law of the land. Now, part of the argument that we are hearing now is that the 10th Amendment may reserve it to the states, and yet the 14th Amendment gives the federal government authority to enforce equal protection of the laws. It says that, and we have a case, as mentioned earlier, the case out of Virginia, Loving versus Virginia, in which a Virginia statute that prohibited interracial marriage was held to be unconstitutional. And many of the federal judges, including Judge Grenade in the Southern District of Alabama, have based their rulings upon Loving versus Virginia. But I think there is a fundamental difference here. The law prohibited interracial marriage, but no one in Virginia would have denied that an interracial marriage was a marriage. It was an illegal form of marriage, but it was a marriage. A same-sex relationship would never have even been remotely considered a marriage up until maybe a couple of decades ago. I always like the story of Abe Lincoln when he asked somebody, how many legs does a dog have? 4. Well, if we were to call the tail a leg, then how many? Well, then he has 5. Lincoln said no, he would still have 4. Just calling a tail a leg doesn't make it a leg. Any more than calling a corn stalk a tree makes a cornfield a forest, or calling a Rottweiler a horse makes a kennel a stable, or calling a same-sex relationship marriage makes it a marriage. That is what we call, in logic, the fallacy of definition. And it's a fallacy being committed quite often in this issue here today. Justice Roberts recognized this during the oral arguments last April when he pointed out to the plaintiff's counsel, you're not seeking to broaden marriage, you're seeking to redefine what marriage is. And that's what this is all about here today. Now, I don't know what the court is going to decide. I think it's very possible they could decide this is a states' rights matter based on Windsor. We don't know for sure. But I would say that regardless of what the court decides in a decision that probably will be released later this month, the issue will be far from over. I've been in Indonesia a few months ago, speaking for Advocates International there. I came back with a new perspective. I didn't realize this, but do you know how many countries in Asia have legalized same-sex marriage? 0. How many in the Arab world? Well, I'll let you guess on that. 0. Africa, only 1, South Africa. Latin America, about half and half. Western Europe largely has endorsed interracial, or that is same-sex marriage, with the exception of North Ireland. Eastern Europe has not. Russia is cracking down on homosexuals. Australia down under is holding the line, and there is no interest in same-sex marriage among the penguins of Antarctica. This is not the worldwide trend that it might seem here. Now, I have about a minute left, but it's 91 degrees out there. I don't think anybody will demand their money back if I quit early here. So let me just say this. Let me just say that ultimately, the radical left on this issue is at war with God and nature. Ultimately, they're at war with the laws of nature and of nature's God. And that means ultimately they are going to lose. But in the process of losing, they can do a lot of damage, even bringing down a civilization. Stand firm, obey God rather than man, and I say, God bless Alabama. God save this honorable court, and God save the United States of America.